Next is the right to prohibit the publication of the proceedings of the House. This is the exclusive right with the House that it can prohibit the full proceedings of the House, as well it can expunge the portions of the proceedings of the House. In MSM Sharma versus Sri Krishna Sinha, the Supreme Court held that if the portions of the proceedings of the House has been expunged, it will be taken as if those words have not been spoken. These privileges we have taken from House of Commons, and they are the same as were held therein. A right to regulate internal proceedings. As per Article 1 to 2 for Parliament and 212 for the state legislative assemblies, no proceeding of the House can be called in question in any court of law. This is a constitutional provision, and the sole and exclusive jurisdiction is there with the chair of the House to regulate its internal proceedings. Right to punish for the contempt of the House. For any breach of privilege or for any contempt of the House, there can be punishment levied upon the person concerned by the chair of the House. For that, there is a committee of privileges which has been constituted under the Parliament, and this committee can summon any member or even a non-member to the House, and if a person does not depose properly, accurately, or gives false statement, that would be a kind of contempt of the House. On the basis of Committee of Privileges report, Houses of Parliament discusses and ultimately takes the decisions. In Raja Rampal versus Union of India, the Apex Court rejected where the charges were levied against the parliamentarians that they have taken money for the asking of questions within the Parliament. Those charges got proved when the Committee of Privileges asked the members, and ultimately investigations were done and the charges got proved. They were expelled. The proceedings were that they should be expelled from the House of Parliament. Supreme Court, on the basis of the Committee of Privileges report and on the basis of decision of the House of Parliament, held that they can only review whatever has been taken as a decision by the parliamentarians. Only review, cannot take decisions. Decisions have to be taken only by the chair of the houses concerned. With regard to these parliamentary privileges and their relationship with fundamental rights guaranteed under Part 3 of the Indian Constitution, there is a very interesting case. In Gunupati Keshwaram Reddy versus Nafisul Hasan, it was held by the Supreme Court of India that fundamental rights guaranteed under Article 22 have to be fulfilled for the protection granted to the legislators under 105 and 194. So, you cannot detain a person without any reason and without producing him before magistrate, as has been provided under Article 22, even if he has breached the privileges of the houses. In the second case, it was held that fundamental rights otherwise do not prevail over the privileges, and freedom of speech and expression is subsidiary or supplemental to the parliamentary privileges granted under Articles 105 and 194. That is, in MSM Sharma versus Sri Krishna Sinha, it was held like that. The conflict between judiciary and legislators' privileges came into focus in the case of Keshwa Singh or UP Assembly case. It is a reference case which is also cited as in re-reference under Article 143, wherein the privileges and the role of judiciary has been substantially said in the following words. He says, I wish to note that it is not necessary for our purposes to make a distinction between privileges, powers and immunities. They are no doubt different in matter of their respective contents, but perhaps in no otherwise. Thus, the right of the House to have absolute control of its internal proceedings may be considered as privilege. Its right to punish one for contempt may be properly described as its power, while the right that no member shall be liable for anything said in the House may really be an immunity. In the year 2002, the National Commission to review the working of the Constitution with regard to parliamentary privileges noted that the privileges of the legislators should be defined and delimited for the free and independent functioning of Parliament and state legislatures. Obviously, the codification of privileges would not only strengthen the rule of law, but the democratic setup of our country as well. There are numerous instances with regard to breach of privileges by the members of Parliament or state legislatures. Like recently, Aam Aadmi Party member of Parliament, he filmed a video clip when he was going from his home to Parliament and recorded all the areas which are very sensitive areas of House of Parliament and put the whole video clip on the social network site, because of which the sensitive areas of Parliament come into danger and which was held as a breach of privilege by the House of the Parliament. A 9-member committee charged him that this is a breach of privilege and punished him also, but some members were not in agreement with regard to the quantum of punishment granted to him. Similarly, Congress moved a motion of breach of privilege against Rajya Sabha member Mr. Arun Jaitley for his comment that Andhra Pradesh would be given a special category status, but cannot be given actually because 14th Finance Commission has not agreed upon that. Later on, when it was found that 14th Finance Commission has not said anything with regard to grant of special category status of any state, it was found to be that Arun Jaitley was saying something which was never said by the Finance Commission at all, and that is why there was a breach of privilege motion against Arun Jaitley by the Congress government. So, similarly, there can be so many instances of breach of privilege for which the members of Parliament and state legislatures can be held responsible, and action can be taken against them on the basis of report of the Committee of Privileges and decision taken by the House or Houses concerned.